So let's get this show on the road. Welcome, everyone. A couple of housekeeping items. Participants will be muted, but we encourage you to use the chat box to ask any questions, or you may raise your hand and I will happily unmute you. And we want this to be interactive, and we want you guys to leave with a wealth of information. So please feel free to ask any questions and raise your hand. And we also welcome you to have your cameras on if you would like. Just also click on the view button on the right-hand corner and click on view speaker to have the speaker view at all times. Let's see, and that's it. Let's get started. Welcome to our Estate Planning 101 UNCG Alumni Lunch and Learn. My name is Yubi Aranda Sandoval. I am an Assistant Director in the Office of Alumni Engagement. It is my pleasure to introduce you to our guest speaker, Justin. Justin is a partner in the law firm of Johnson, Pedrick and McDonald, PLLC in Greensboro, North Carolina, where he focuses his practice on estate planning, estate administration, and adult guardianship. He completed a double major in business and French at UNC Greensboro. He stayed on at UNCG as a full-time staff member in the university libraries and did graduate level work in Romance languages. After leaving UNCG, he graduated cum laude from Elon University School of Law and earned an LLM from University of Florida. Justin has served on the board of directors of Guilford Green Foundation and the Greensboro LGBTQIA Center, Benevolence Farm, and the Greensboro Estate Planning Council, and the Greensboro chapter of Society of Financial Services Professionals. Justin continues to be involved with his legal alma mater, Elon Law, as an adjunct faculty member and a student mentor. Welcome, Justin. It's a pleasure to have you.
Thank you very much, UB. Thank you for allowing me to be here today. Are we ready to just jump in then?
Yes, go right ahead. Take it away.
Okay, let me see if I can share my screen here. Okay, do you all see that now?
Yes.
Okay, perfect. Thank you all for being here, first of all. It's a real pleasure. I enjoy giving these talks, especially to groups of people from my alma mater, UNCG. And we are going to talk about estate planning right now. I've been practicing in this area for about 10 years. I went to law school wanting to do estate planning, and I consider myself very fortunate that that's what I get to do every day now, helping people to get their affairs in order. And my contact information appears here on this intro screen. It's also going to be at the end, and I think that Yubi said that she was going to put that in the text chat for everyone to access as well. So how can estate planning help you? I mean, you obviously have an idea about that, and that this is something that you need to do or you wouldn't be here. Excuse me, I seem to have a frog in my throat. Okay, and so we're going to dive right in and talk about that. A lot of people, when they think about estate planning, they think about a will. They think about who's going to inherit from them after their death, and they think about who is going to be their executor, who's going to step into their shoes to wrap up their affairs, to handle all of that. And that is a big part of it. But estate planning can help you and your loved ones, not only after your death, but also during your lifetime. You know, there is something in between being upright and having your wits about you and being horizontal and in the ground. People often do become disabled and become unable to handle their affairs during their lifetime, and that is another place where estate planning can help. You know, when you're thinking about putting together your plan, you want to think about whom you want to benefit, who are the important people in your life. And, you know, that could be your spouse, it could be your children, it could be other important people as well. And you want to also think about what it is that you have that you can use to benefit those people. What assets? Do you have a home? Do you have a retirement plan? Do you have some other investments? That sort of thing. We already touched on another aspect, something else you need to think about. Who is going to handle all of this? Who do you want to be your executor, the person to step into your shoes after your death to wrap up your affairs? And who do you want to be your agent, the person who might handle your affairs during your lifetime if you're not able to do that? And then how can we do all of this efficiently? There are tax implications that could come from the administration of your estate, and as well as other costs that are associated with it. Making an estate plan can reduce the involvement of the court in your affairs. If you die and you don't leave behind an estate plan, if you don't plan, then the court will step in and they will supervise all of that. Yes, you might have an executor or an administrator, but the court is going to look over their shoulder to ensure that they're doing their job correctly, and there are costs associated with that. And with regard to those costs, putting together a good estate plan can help to ensure that more resources go to your family instead of to the courts or to the tax person or to the attorneys. When I teach wills and trusts at the law school, and the book that I use makes a very good point that your estate plan is sort of a living, breathing thing. It's not a one and done question. It does need maintenance. And I recommend to my people to come back and see me every 5 to 7 years or as life events dictate. And I've included there some events of what is a dictator in this case, including marriage and divorce and birth and death of important people in your life. So what are some of the documents that you might put together if you were to come to see me to do your estate plan? There are several documents that every person needs as part of their estate plan, and there are some that are optional as well that really depend on your situation, whether you need them or not. The necessary documents that everybody needs include a healthcare power of attorney, a living will, a HIPAA authorization, a financial power of attorney, and then a will. Some optional estate planning documents that some other people might need, but not everyone, include a trust, as well as maybe an authorization to consent to minor to healthcare for a minor, or a designation of a standby guardian. And we're going to go through and look at each of these documents and what they do. And we're going to start, we're just going to go in order and start with the healthcare power of attorney. This is a document in which you name an agent to make your healthcare decisions for you during your lifetime. Now, for the most part, your agent's power expires at your death, and that makes sense because what healthcare decisions are you going to have to make after you're dead? Well, actually, your healthcare agent could have some power regarding the disposition of your remains. For example, whether you're cremated or not, and then where you're buried. And you can specify all of that in your healthcare power of attorney, as that's mentioned here. This is also called, depending if you come from another state or if you've lived in another state, you might also hear this referred to as a healthcare proxy or a designation of healthcare surrogate. Some states in the Northeast call it a healthcare proxy. I'm also licensed to practice in Florida, and in Florida we call this a designation of healthcare surrogate. They're all very similar. And having this document in place can help you to avoid a guardianship, can help you to avoid having the court appoint someone to make these decisions for you. And we're going to look a bit more closely at what happens if you don't have these documents toward the end of the presentation, after we've gone through each of the documents. A second document that works alongside the healthcare power of attorney is called a living will. And that's a document in which you have the opportunity to say, hey, if I am nearing the end of my life and it looks like I'm going to die soon, I don't want life prolonging measures that are going to artificially prolong my death. And that could include certain types of medical care, and it could also include food and water through a feeding tube. And you could also hear this referred to as an advance directive. One final healthcare document that you should have is a HIPAA authorization. Now, your healthcare agent has power under HIPAA. HIPAA is a federal health information privacy law, first of all, and that federal law gives your healthcare agent access to your medical records, but this is just kind of a backup. It's a document that says, that you sign, that says my healthcare agent absolutely does have access to my medical records. And that's important so that your healthcare agent will have good information on which to base the decisions that you've asked them to make. Yeah, I'm just looking at the slide here, speaking extemporaneously. So I just want to make sure that I'm hitting all of the points that I want to make. We'll talk about a trust as well, and a trust can kind of bridge the gap between someone managing your assets during your lifetime and then wrapping up your affairs after your death. And it could be important for your trustee to have access to your medical records to see, hey, has this person lost their capacity? Does the successor trustee need to step in? And so the HIPAA authorization is going to handle that as well. So moving on from healthcare decisions to decisions about your finances and personal business, we're going to look at the financial power of attorney. This is a document. It's similar to a healthcare power of attorney because you are creating new powers in someone else and naming an agent to act on your behalf during your lifetime, just like you are with a healthcare power of attorney. A difference between those two types of powers of attorney is subject matter. The healthcare power of attorney deals with your healthcare and medical decisions. The financial power of attorney deals with your finances and personal business. And you'll probably hear this referred to as a durable power of attorney, or just a POA, or maybe even a continuing POA. And often I hear people referring to the person that you name in here as the POA. This person is my POA, or this person has my POA. More correctly, though, the document is the POA and the person is an agent. That's just a semantic distinction. By having this document in place, you can help to avoid the court appointing a guardian to handle your assets for you. That involves, guardianship involves basically a trial with a judge determining whether you have the capacity to make your own decisions or not. And then the guardian, if they're managing your assets, they have to account to the court every year. And that involves public disclosure and fees and costs. And so having a financial power of attorney in place is one of the best things that you can do to preserve your assets for yourself during your lifetime, as well as for your loved ones. So these documents that I've been talking about really focus more on what happens during your lifetime while you're alive, and they're important to have in place. But another important aspect of an estate plan is what's going to happen after your death. And that's where we move over and we look at a will. And a lot of people are familiar with wills. They're embedded sort of in our culture, and we see movies where wills and a person's death and the distribution of their estate plays a big role. But let's think about what a will does and what a will doesn't do. That's helpful to think about it. Your will does give you the opportunity to name an executor, and your executor is the traditional term that we still use here in North Carolina for the person who's going to step into your shoes and wrap up your affairs after your death. You might hear this called an administrator. That's similar. In Florida, we use the term personal representative, in which you might hear that term as well. In your will, if you have minor children, you have the opportunity to suggest whom you want to be the guardian, whom you want to take care of your children after your death. And you can, of course, specify who's going to inherit your things after your death. And you can make other wishes known, including mentioning that you want to be cremated, for example. And if you have family members that you don't want to inherit from you, you can say that as well. This is also called a last will and testament. Last because the most recent one controls. If you make one that's later, it's going to control if it revokes all of your old wills. Will and testament because American law is weird, and it's a strange combination of English law and other things, and we tend to use two words to refer to one thing in American law, so will and testament. There was a distinction way back in jolly old England in ancient times, but we don't make that distinction any longer. That's a bit of the law professor coming out in me. I'm getting off track here. So what a will doesn't do, it does not control who inherits retirement benefits and life insurance. That's very important. You don't want your will to control those things. Those types of assets have separate beneficiary designations on them. When I started working at UNCG, after I finished my undergrad work there, I worked with human resources and I got my retirement all set up, and I named who I wanted to be my beneficiary of my state retirement. And I believe that UNCG offers also some optional life insurance, and you would have the opportunity to name your beneficiary on there as well. Of course, you might have retirement and life insurance assets elsewhere. You might have a separate IRA out there, or you might have bought another life insurance policy that's totally separate to your work at UNCG. Those are all going to have beneficiary designations on them, and those control where those assets go, not your will. If something goes wrong and those assets do end up in your estate, then the court is going to take a cut of fees based on those assets. And this life insurance and retirement assets, they have protection, special protection from your creditors. So if you die and leave behind bills where you owe people money, those don't go away. That's one of the jobs of your executor, is to pay your bills. But they can't use your retirement benefits and your life insurance unless something goes wrong, and those do end up in your estate. So it's very important to keep these beneficiary designations updated. Another thing is that if you make a will and you benefit your spouse and you later divorce your spouse, then your spouse is automatically cut out of your will because of the divorce. But they're not cut out of receiving your life insurance and retirement benefits. If you name your spouse as your beneficiary on your life insurance and retirement benefits, and you later divorce and then die after the divorce, your ex-spouse is still going to get your life insurance and your retirement benefits. And so another reason that it's very important to keep those beneficiary designations up to date. You can also name a beneficiary on a bank deposit account, like a checking or a savings account. That's called a POD, a pay on death designation. Or you can name a beneficiary on a corporate stock or some other type of investment or security, or a brokerage account. That's called a TOD, a transfer on death beneficiary designation. You might own certain types of assets jointly with someone else. Probably your home, if you're married, or if you have a domestic partner, then you might own your home jointly with someone else. And if that joint ownership carries a right of survivorship with it, then your will is not going to control where that jointly owned asset goes. Often, we have checking accounts with our spouses or our partners, and you can own automobiles with the right of survivorship as well. Your will is not going to be able to waive an accounting for the administration of your estate. When your executor goes to the court and works with the court to administer your estate, they're going to have to file an inventory of your estate and provide accountings each year until your estate is finished. And you can't waive that. In some other states you can. In Florida, we do it all the time. But in North Carolina, that's not possible. Your executor must account to the court. And your will is not going to do much to protect your privacy either. I've said that one of the things that your executor has to do is file an inventory of your estate with the court. And that's a public document that anyone can then go into the courthouse and obtain a copy of. So if you want to help minimize some of these court costs and protect your privacy a little bit, then what can you do? You can put together a trust. Now, a trust isn't the right thing for everyone to do. Some people just don't need a trust. Some other attorneys would agree with me, but law is as much art as it is science. And so reasonable attorneys could disagree. I think trusts are optional for most people. So who would need a trust? Someone who has minor children, for example. Minor children cannot own assets in their own name. They need a custodian or a guardian to help them, and guardians have to account to the court in the same way that an executor does. So one way to get around that is to put a trust in place to hold assets for your children. Maybe you have disabled beneficiaries who need means-tested public benefits like Medicaid or what we used to call food stamps and that sort of thing. And you want to protect those public benefits. You don't want them to inherit a gob of money from you, or a goblet if it's small, of money from you. And so you hold it in trust and set it up in a particular way so that it protects their benefits. People for whom privacy is important. We have talked about that. If you put assets into your trust during your lifetime, that same trust can dispose of them after your death. And if it does, then those assets aren't going to pass through your estate, and they never show up on the court's radar, or at least not in the same way as they do an inventory and an accounting of your estate. people who have cumbersome, valuable, or difficult to appraise assets. And so I'm thinking about people who have, maybe they have a business that's set up as an LLC, and it's might have valuable real estate in it, or it might have valuable intellectual property or something like that. You might want to put that into a trust, and that could help you to avoid having those assets appraised, and it will help you to avoid public knowledge, public disclosure of those assets. And in North Carolina, as well as in Florida and many other states, we can set up a trust for the benefit of our pets. You know, pets are as much family as our spouses and children are in many cases. And North Carolina law does allow us to set up trusts for our pets. I have done some of these, and people who love their pets tend to be very particular, and you can include very particular wishes in a pet trust here. So the advantages that a trust brings to the table are privacy. It can help to lower the court fees that are associated with the administration of your estate, and it can help to simplify the administration of your estate as well, because you're not going to need to render an inventory and account to the court in the same way. And you might hear trusts referred to as a living trust, that's a very common term, or a revocable trust, or an inter vivos trust. There are trusts out there that are irrevocable, that you might need sometimes for particular reasons. Those tend to be for tax savings. If you have a very large estate and you're going to owe estate tax, then an irrevocable trust can help you to avoid that. And as opposed to a living trust, you might hear someone talk about a testamentary trust. That's a trust that's built into your will. That's not going to give you the same privacy and cost reduction that a living trust is, but that can help you to set up a structure for your minor children or for a disabled beneficiary. So if you do have minor children, you might need a trust. There might be some other estate planning documents that you need as well. One of those is an authorization to consent to health care for a minor. So think back to earlier in the presentation, we talked about a healthcare power of attorney. And that's where you name an agent to make medical decisions for you during your lifetime. Well, this is similar. It's like a healthcare power of attorney for your children. You, the parent or guardian, are naming an agent to make healthcare decisions for your child. And this is useful, for example, if the child goes away to summer camp, maybe it's camp grandparents, you know, they go to spend a week or two, or hey, just stay the whole summer with grandma and grandpa and grandparent, and you want the grandparents to be able to take them to the doctor if something happens while they're there. This is a perfect situation for that. I mentioned that you can suggest a guardian for your children in your will for after your death, if your co-parent is also deceased. But then we talked about, well, what happens if you aren't able to make your choices for yourself during your lifetime, but you're not dead? And that's where powers of attorney can be helpful. Well, we have something similar here. A document called a designation of standby guardian. So you can suggest someone to be the guardian for your children during your lifetime if you're no longer able to take care of your children on a permanent or semi-permanent basis, because maybe you have a terminal disease that is progressing, or if you have some sort of debilitation or incapacity for whatever reason, you can go ahead and suggest someone to take over during your lifetime. Now, I want to clarify something here. I've said that you can suggest a guardian for your children in your will, or in this document that's called a designation of standby guardian. And I'm going to underscore that, because you can't direct the court to appoint someone. The court is going to hold a hearing, and the court is going to make a decision about who should be the guardian of your children if both you and your co-parent are out of the picture, based on what the court finds to be in the best interest of your children. But when the court is looking at all the evidence and considering what is in these children's best interest, it's going to put a very heavy weight on what you, the parent or the guardian, say is in your children's best interest. So the court puts a lot of regard, in these documents and what the parent has to say about what's in the children's best interest. So I've talked a little bit about taxes and how those can touch your estate and how you need to kind of think about that when you're planning your estate. And people sometimes ask me, I don't want my heirs to have to pay taxes on this, my beneficiaries, or how do I avoid estate taxes and that sort of thing? Well, one thing that some people think about as a tax are the fees that the court imposes on the value of your assets that pass through court supervised administration, that pass under your will through your estate. And in North Carolina, those fees aren't terribly high. It's 0.4% of the value of those assets. So for example, if you have a car that is passing under your will and through your estate to a beneficiary that's worth $10,000, the court is going to collect $40 of fees on that vehicle. If you have a brokerage account or a money market or a CD that's worth $100,000, then the court is going to take $400 worth of that for putting their eyes on that sort of thing. And here's an example of how a trust can reduce the cost of administering your estate. Because if you retitle that money market account into the name of your trust during your lifetime, or if you name your trust as the POD beneficiary on your money market account, it's not going to go through your estate. It's either going to be in your trust or it's going to pass into your trust automatically at your death. And the court is not going to collect those fees. That's $400 extra of that $100,000 asset that's going to go to your family instead of to the court. So income taxes can also figure into an estate administration in a few ways, because estates and trusts are tax-paying entities. So if you have a corporate stock that ends up in your estate for some period of time, the dividends that corporate stock pays are going to be taxable to your estate. And there are some things that you can do to minimize that or mitigate that, but that's really beyond the scope of what we're talking about today. If you leave behind a traditional retirement account, like an IRA or a 401k, that you take money out before your employer takes taxes out, and you put that pre-tax money into your retirement account, when that money comes out, of course, it's going to be taxed. And if someone inherits that from you, then the beneficiary of that account is going to pay the income tax on that money that they take out. So that's another example of how income taxes can figure into this. Some people want to give away property during their lifetime, houses, cars, stocks, even other things like that, so that it won't pass through their estate after their death. And that is one way to protect your privacy and to avoid the fees that are associated with estate administration, but it's a bit of a false economy. And that has to do with the basis of property and capital gains taxes. And this is going to get a little bit complicated, so please bear with me, and I'm happy to answer questions about this later as well. If you have corporate stock that you paid $1,000 for during your lifetime, and it's now worth $10,000, if you were to sell that stock, you would have a $9,000 taxable capital gain, okay? If you were to give away that stock to someone else during your lifetime, then the recipient of that gift is going to take a transferred basis. So their basis in that stock is going to be the same as yours. And if they then turn around and sell it, they're going to have that same $9,000 taxable gain. But that stock for which you paid $1,000 for, if you let someone inherit that from you, and when they inherit it, it's worth $10,000, their basis gets stepped up to that fair market value. So if they've inherited from you this stock for which you paid $1,000, now is worth $10,000, their basis is that $10,000 fair market value stepped up basis. So when they sell it, they'll have no taxable gain. And that principle is applicable to many other types of assets as well. So it could be better to let someone inherit property from you rather than you give it to them. Just an example of how income taxes can affect your estate administration. We do still have estate taxes only at the federal level, as far as North Carolina is concerned, and Florida as well. Some other states do still have estate taxes, but North Carolina is not one of those. And the exclusion amount, so that is the amount of assets that the estate tax ignores, is so high that it's rarely going to touch anyone. So for people dying in 2021, the exclusion amount is $11.7 million per person, and that's portable between spouses. So if you're married, you can think of yourselves as a, what is that, $23.4 million package. So if you have $11.7 million worth of assets, A, congratulations. B, please call me because you have an estate tax issue. But if you have less than $11.7 million, then you don't need to worry about estate taxes under current law. Now, there are some conversations. They're thinking about lowering that amount because it's very high by historic measures. It has been in the early aughts, it was around 3.5 million. And in the 90s, it was between 500,000 and 1 million. So it's very high right now. And then there is also something called the generation skipping transfer tax. So if you try to avoid the estate tax that your children would have to pay by leaving assets to your grandchildren, the generation skipping transfer tax is going to come in and kind of fill that in. So that's gets a little complicated. And as I said, this is not applicable to very many people in this day and age. But if it is, hey, that's a great problem for you to have. So what are some other things that you need to think about if you don't put together your own estate plan? So when I'm doing these types of seminars in public, in face-to-face in a room full of people, I like to sort of poll the room and say, if you don't have a will, please raise your hand. And people, who haven't done their wills yet, sometimes sheepishly, but they'll often raise their hand. And I say, well, I'm here to tell you that everyone in this room has a will. If you didn't put it together for you, then our General Assembly, our state legislature has made your will for you in the form of intestacy statutes. So if you don't make your own will, then we have state laws that say where your property is going to go, who will inherit from you, and who has priority to serve as the administrator of your estate to wrap up your affairs. And a lot of people, especially if they're married, they think, well, my spouse is just going to inherit everything. And that might not be the case. Yes, the spouse gets the first bite, but the spouse doesn't automatically inherit everything. If you have children, your spouse is going to have to might have to share with your children. And if you don't have children, your spouse might have to share with your parents. And so think for just a moment how that might look. If you own your home in your individual name, because maybe you lived in it before you were married, and then your spouse moved into your home and you've never retitled it, after your death, your spouse might end up co-owning the home in which they live with your parents. How do you think your spouse is going to feel about that? That could be a bit awkward. But again, putting together a will, you have the opportunity to say who inherits from you and opt out of these statutes. So this is just what happens if you don't put together your own plan. If you don't put together your own plan, that means you don't have a trust. That means that all those court fees that we talked about, as well as the public disclosure, are going to be in full effect. And if your children end up inheriting from you and they happen to be minors, they're going to need a guardianship. The court is going to have to appoint someone for them to manage those assets for them. And then when they turn 18, they're going to get every bit of it. I don't know about you, but I wasn't making the best decisions when I was 18. And so you might want to set up a trust and put a structure around those assets for your children so they can inherit what you're leaving behind for them gradually. If you haven't made your own financial power of attorney, then a court might appoint a guardian to handle your assets for you. And the same thing, if you haven't made a healthcare power of attorney, well, our state law has a priority order of who gets to make your healthcare decisions for you. But if those people disagree or there's no one in that list, then same thing, the court could appoint a guardian for you to make your medical decisions. And that might end up being the same person, but it might not. It wouldn't necessarily. The court is going to determine who will care for your children without knowing who you would want to do that. And I had that asterisk there because that's where I wanted to talk about the hearing process and how the court appoints a guardian for children, but we've already covered that. And then if you don't make a plan, if you have a very large estate and you don't make a plan to deal with that estate tax or generation skipping transfer tax, then 40% of what you leave behind could end up going to the federal government. That's not a great feeling. So, I do this for a living. I'm an attorney and I help people to put together their estate plans, but I'm really just one of a member of a team that you should have to be helping you with this. So who are the other people on that team? You're a financial advisor. This is a person who can talk to you about your goals. When do you want to retire? At what age? What do you want your retirement to look like? Do you want to sell your home in Greensboro and maybe move to the mountains or move to the beach or have a home in each place? Do you have children that you need to plan for as well? Are you going to need a particular type of income stream in your retirement? Where do we need to invest your money now in order to make that a reality? Those are the sorts of things that a financial advisor can help you with. You should probably have a CPA helping you as well. Many of us do our own taxes, and that's great. But if things get a little bit more complicated, if you have some sort of off-the-wall investments, or if you have your own business, then a CPA can help you with those types of things. And your CPA and your financial advisor can work together to figure out not only where do we need to invest our money, but do we want to put that into a tax advantaged investment like a traditional IRA, or do we want to put it somewhere else, maybe a Roth IRA? Maybe we want to pay the tax now and avoid the tax later, that sort of thing. Your CPA and your financial advisor can work together to help you sort that out. Maybe you need an insurance advisor. What are the risks that could harm your estate, your financial plan? If you're in an accident that's your fault, that could create liability. How do we want to transfer that risk to an insurance company? And other sorts of things. If you have a large estate that's going to be subject to estate tax, there are ways that you can leverage life insurance in order to mitigate that liability. People are living longer now, and more of us are needing expensive care as we age, but Medicare and private health insurance don't pay for long-term care in a nursing home, for example. Medicaid does, but you have to pretty much exhaust your assets. You have to spend all of that money that you were going to use to live on in retirement and hopefully leave behind for your loved ones after your death. You have to spend all of that before you can qualify for Medicaid. So long-term care insurance might be a thing that you'll want to purchase so that you won't have to exhaust your retirement savings in order to pay for that care. Your banker, if you might want to develop a relationship with the banker, particularly if you own a business or if you're going to start up a business after you retire. A lot of us started working for the state as soon as we finished undergrad when we were 22. And so we'll finish our 30 years when we're 52. That's still a lot of life left. You might want to start up a business at that point. I have clients who have done just that. And so a banker can assist you with a loan to get that business started and to help you with cash flow, particularly if it's a seasonal business where your income is not steady throughout the course of the year. If you're setting up that business, you might want a business attorney to help you organize an LLC or set up a corporation, or to make sure that you have a succession plan in place for someone to take that business over when you are ready to retire for real. And then, of course, your estate planning attorney. I look at myself as the person who is building the legal foundation for all of this, setting up the documents so that all the rest of this is possible, so that there'll be someone to handle all this for you if you're not able to do that during your lifetime, and so that the people that you want to take care of, the people that you want to benefit after your death, will have the benefit of all of your work that you've done so hard during your lifetime. And that's all the new information that I have. And now I'm, open for questions. Do we have questions out there? What does the chat look like, Yubi?
We do. We've had a busy chat.
Great.
So yeah, One of the questions that we had towards the beginning is, what about a living will? Does the HCPOA agreement address wishes such as difficult decisions, i.e. remaining on life support, etc.?
Yeah, yeah. So the healthcare power of attorney and the living will that I use are statutory forms that are available in our statutes here in North Carolina. And so you can actually get them for free and complete them yourself. That said, they can be a little bit confusing. There are lots of spaces in there where you can say what you want your wishes to be. And so they're flexible, but that means that they can be a little bit complicated. So I do like to walk through those documents with people. But yes, you can say something like, I only want a feeding tube for 30 days, or I only want, this type of medical care, or I want to be an organ donor, but I only want them to be able to take my eyes and, my kidneys, for example. They are very flexible. I would suggest working with an attorney to do that. At the same time, I recognize that we can be expensive. And so we have a great hospice organization here in town, AuthoriCare, and they do some free counseling. They work with people who want to set up their healthcare powers of attorney and living wills. And that is a service that they used to provide for free. I'm not sure if they still do. And of course, your doctors and your healthcare providers would thank you. And so, yes, those documents are very flexible, and you can make very specific wishes in there. I tend to advise people to err on the side of leaving discretion with your healthcare agent. Pick someone whom you trust, who is kind of in tune with your philosophy of those types of decisions, and then give them the flexibility that they need. But you can specify limits on that.
Perfect. Our next question is, if you have a family farm that does not, if you have a family farm and that does not go, that goes into a trust and you don't want to place it up for sale, do you just keep it in that trust?
That sounds a little bit more complicated than what I can address in a minute or two. If you're going to continue to operate this farm in some way, whether you are selling timber or leasing pasture or actually growing crops, and you said that this is a family farm, which suggests to me that you're operating this in cooperation with other family members. You can have it in a trust for a while. But, oh, you know what? I realize I'm still sharing my screen. I'm going to stop sharing this so that you all can actually see me. You might want to form an LLC and transfer the ownership of the farm in there, and then make an operating agreement for your LLC to specify how we're going to work together to do all of this. That sounds like a good question to ask a business attorney. Or to work with your estate planning attorney to put together a plan.
Thank you, Justin. Our next question, what type of unique documentation or plan is needed to designate a domestic partner with whom you haven't entered into a legal union?
Okay. So, marriage isn't for everybody. And I have worked with couples who were contemplating marriage, and we talked about both the protections that marriage brings with it, as well as the responsibilities, because it goes both ways. I saw a lot of this in right after marriage equality came to North Carolina in October of 2014, and a lot of same-gender couples were saying, "Hey, we can get married now. Do we want to? Is this something that we want to do?" And so it's good to think about that. So think about getting married, because, like I said, it brings a lot of automatic protections, but it also brings some responsibilities. And it sounds like you might have decided that marriage isn't for you, and that's fine. North Carolina law does recognize partnership agreements. You and your partner can enter into a contract for certain things about how you want to divide up the responsibility for bills and that sort of thing. And if you break up, how you're going to split up jointly owned assets. You can do that yourself. I would suggest you work with a good family law attorney who is accustomed to working with unmarried couples. Actually, each of you would need your own attorney in that case. But from my perspective, a will is just putting together a traditional estate plan that has all these documents that we've discussed. That's going to get you very far. Because if something happens to one of you and you're injured and end up in the hospital, you can say that you want your partner to make those healthcare decisions for you, not your parents or your siblings or your adult children. And if something happens to you and you die, you can specify that your partner inherits from you. And so a traditional estate plan is going to get you very far. There are other more sophisticated options at your disposal as well through that type of partnership agreement.
Thank you, Justin. I think that was very helpful. Our last question, in general, what are legal fees to set up a trust? My parents have a will, but they are both collectors, which has made me wonder if a trust would be a better option because I am unsure how all their stuff will be valued.
So legal fees vary quite a lot. You know, what I would suggest is do your research as far as what attorneys in this area provide this type of service. A lot of attorneys will have information on their websites about the types of clients that they serve most often. And so do that type of research. You might talk to some community organizations. If you have, you know, a particular identity and there's a community group like Guilford Green Foundation serves LGBTQ individuals. And so Guilford Green might maintain a resource of attorneys that are particularly adept or particularly enjoy working with LGBTQ individuals. That's a good research. Do your research, find an attorney with whom you like, and then reach out to them and ask them what their fees are. Some attorneys do this at their hourly rate. That's how I do my work. And some attorneys do this as a flat fee. You know, they'll put together a package for you and do it and tell you up front, here's your price. And so attorneys have different types of policies on this, and the costs are going to be all over the board, really depending on what it is that you want and what you need. But don't be afraid to ask those questions up front.
We have an attendee who just came in a little late, and she says, wills and trust. When do you need a trust and when do you need a will? When is it okay to have just a will?
Yeah. Again, it really depends on your particular situation. You know, where are you in your life? What do you have? And how do you use it to want to benefit the people that you care about the most? When do you need a will? On your 18th birthday, quite frankly. When do you need a trust? There is a slide back there that talks about people who need a trust. Generally, people who have minor children or who have disabled beneficiaries who get public benefits, or if you have awkward or cumbersome assets are people who get the most benefit out of a trust.
Thanks again for covering those, Justin. I believe those are the questions we have. If you guys have any other pending questions, please put them in. Those are all welcome. Let's see. Or you're also welcome to raise your hand and I can unmute you.
UB, I see
Yes.
a question about the PowerPoint slides. I'm happy to send those to you after the presentation so that you can share those with folks.
Yes, thank you. And we also we are recording this session. So this recorded session will be forwarded to everyone who has joined us and those that registered as well. So we'll be sharing this presentation through a link. So just be on the lookout for that. Let's see. All right, well, I think that is it. Well, we have one more. How reliable are the online platforms for setting up these types of things?
You know, that is tricky. I have made a lot of money advising executors of estates where the person made a will online or made a will out of a form book that they bought at an office supply store. And I don't think that the problem is necessarily with the documents themselves, because what I've observed is that these companies often hire attorneys to put these documents together for them. And although there are sometimes issues and problems with the documents themselves, where I see the problems arising is that the documents, they're either a one-size-fits-all approach, and so they might not address your particular situation in the way that you need, or when the folks are going through and using documents from these websites and online resources, they don't have the benefit of an attorney to kind of walk them through and explain to them what the things mean. And just one example of that is the living will. You know, the living will has lots of options in there, and you make your initials in the different blanks to say what you want your choice to be. And I have often, you know, when I make drafts of these documents and send that out to folks, people will send it back to me and say, okay, you know, I've signed this, and they've gone through and they've initialed everything, every spot, you know, including in the questions where it says, initial one of these to make your choice, and they've initialed all three. Or they signed it, and then some of these documents need to be witnessed and notarized, and if there are no witness signatures on there and no notary. And they say to me, well, can't you witness it now or notarize it now? And no, a notary can't do that. You have to be physically in front of the notary when you sign, or you have to be in front of the notary and say, this is my signature that I put on there. And so a notary can't notarize something after the fact. And so it's not just the content of the documents, it's the way that you walk through them and the way that you complete them is where I see problems arising.
Thank you. Thank you, Donegan, for that last question. Also, I do want to remind people that we will upload this to our website, so it will be shareable in our YouTube channel. Justin, it's been a pleasure having you and sharing all this important and valuable information. Thank you, Justin. If you want to contact Justin, I am going to put his information in the chat box for everyone to jot down if you just want to copy and paste that. There it is. Or if you would like to contact the Office of Alumni Engagement, you may contact me through email or via LinkedIn as well. And I'll put that in the chat box as well. And thanks to our Office of Planned Giving for also being here. If you would like to reach out to our Planned Giving office, or if you have any questions, you may contact David Landers, and I will insert his information in the chat box as well for you to have. Justin, do you have any closing remarks that you would like to share?
You know, this is something that it's easy to put off, and a lot of people wait to do this type of thing. But when you need these sorts of documents, it's often too late.
Yes, been there, done that. Well, thank you everyone so much for your time and for joining us this afternoon. It has been a pleasure having you all and participating in this Lunch and Learn session with us. That is all for today. Thanks for joining us, and buenas tardes.
Hasta luego.
Hasta luego.